Good evening and welcome once again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Atty. Ramon Esguerra. He is a member of the defense panel. Good evening, Mr. Atty. Esguerra.
Good evening, Les.
I'm going straight to my question, Atty. Esguerra, regarding what has transpired today at the Senate Impeachment Court. Do you agree that the Senate President, when he said that it is the responsibility of the prosecution to invite Justice Sereno to testify in the Senate Impeachment Court and not the latter, and not the Senate Impeachment Court itself?
Yes, you see, there was already a ruling earlier made by the Senate that it will not issue any subpoena to compel the attendance of any justices of the Supreme Court. That's one. And then two, on February 14, 2012, the Supreme Court came up with a resolution actually explaining the principle of judicial privilege in terms of confidentiality of internal deliberations of the court. And there was guidance issued by the Supreme Court on the appearance of justices of the Supreme Court as well as court employees, other court officials in proceedings like this. And the bottom line requirement, fundamental of that, will be the approval by the Supreme Court and Bank of any such appearance in court, or whether or not a particular court official or employee or even a justice should abide by any compulsory process.
Attorney, but what if the person invited to appear before a Senate Impeachment Court refuses to appear? Can the prosecution, and that's what I gathered today, can the prosecution transfer the burden to the Senate Impeachment Court to do the inviting?
Yeah, you see, those are two different concepts. No?
Yes.
When you say that the Senate is inviting or extends an invitation to a person for the person to appear and shed light on a particular matter, that can be in the capacity of as a resource person or as a witness, and that's why there was a clarification made that from the prosecution, and the prosecution said that the presence of Justice Sereno will be more to be a witness for the prosecution.
That's right.
She will appear here as a witness for the prosecution and not as a resource person. The other side of the coin is the subpoena that we are talking about, which is a compulsory process, well within the powers and prerogatives of the Senate sitting as an impeachment court. And we have discussed that earlier. No? There is a bar, there is a ruling by the Senate that it will not subpoena justices of the Supreme Court, and the other will be whether or not it will be covered by the judicial privilege or the prohibition in that Supreme Court resolution. Now, what the Senate noted, observed, as you can see from what Senator Defensor Santiago said and what the Senate President said, was that the prosecution was actually passing the buck. Meaning passing the buck in terms of making sure that their witnesses appear and testify for them to the Senate, which should not be the case.
Well, because Atty. Esguerra, on that note, a member of the prosecution today hinted that they were having a hard time with their witnesses. In fact, they said that they're having a hard time with their case against the Chief Justice. And then a member of the Senate Impeachment Court, Senator Joker Arroyo, said, but you have the president right behind you. So, what are your thoughts on that?
Well, you see, that cannot be denied. No, it's maybe you can say, you may refer to it as an open secret.
That's right.
That the prosecution has the full backing of the president. We have been saying all along, as we have observed, that the resources of the government are actually at the disposal of the prosecution.
Yes.
And the president, no less than the president, has made it clear that he wants the Chief Justice ousted. Of course, to us, the limited perception that we can say of this is that this is real intemperance on the part of the president on the Senate impeachment proceedings. But he is the president, and you know, he exercises vast power.
Yes.
And that the prosecution is finding difficulty in looking for witnesses is their problem, because they have, as noted and observed by the Senate President, they have filed this complaint, the articles of impeachment, without really being assured that they have evidence on hand to prove each and every allegation in their complaint.
Yes. Again, Atty. Esguerra, Senator Escudero mentioned that it is the prosecution's obligation to present witnesses and not the Senate Impeachment Court. Do you agree with him?
Well, yes, because if you have a case, that means that you have the evidence. You will not file a case if you don't have the evidence. But what would seem to have happened here, and what appears to be clearly to have happened here, is that the prosecution filed the complaint first and looked for the evidence later,
yes,
which is to us, of course, a fundamental violation of the due process rights of a person accused of a crime. Because you do not file an information, which is in a criminal case, or you do not file a complaint without first, having with you the evidence to support each and every allegation of the information in the case of a criminal action, or the complaint in the case of a civil action. You do not go to court, therefore, without being equipped with anything. And this is what happened to them, because they filed the case without really the evidence on hand with them.
So you must always come to court prepared.
Yes, that's it. That's basically. You remember that the burden here is on the prosecution,
yes,
to prove each and every allegation.
Yes.
They accuse, they must prove. That's the fundamental essence of the process here.
Upon seeking a clarification from the presiding officer, I believe they got the ire of another member of the impeachment court, saying, and I quote her, that they're putting the impeachment court and the Supreme Court on the head on collision course.
Loggerheads actually, loggerheads, that's right, and that should be avoided, and that is what the Senate President, in leading the Senate Impeachment Court, is trying to avoid. He wants what he refers to as co-equalness,
yes,
the coordinate nature of the relationship between among the three branches to be respected, and so the leadership of the Senate does not want to impose its will upon the Supreme Court, which is an independent co-equal, an independent branch and a co-equal branch of the Senate, or the Congress, of which the Senate is a member, is a part of.
We heard earlier that a member of the Senate Impeachment Court alleged that there is a paid survey right now involving some students of the University of the Philippines. What is your reaction?
I really do not know anything about it, but that's a little shocking.
Okay.
At the very least, surprising. I think the prevailing sentiment, UP is a bastion of radicalism, supposedly, and they are always against the status quo. And so anything that will agitate them to do mass actions, they will bite. And so in this particular case, I think the premise is the unpopularity of the Chief Justice in connection with the unpopularity of a former president. And they're of course raising all issues that they can, attacking the Chief Justice, attacking the very institution that the Chief Justice represents, and that's the only way of them being able, or succeeding rather, to undermine the power people in the institution, which is the Supreme Court. And they have to attack, therefore, the Chief Justice to be able to attack also at the same time the very institution that the Chief Justice represents.
Let me quote the Senate President when he said, "The remedy is not from the impeachment court, but from the Constitution." Is this short of him saying that, what about the prosecution? You seem to come unprepared.
Well,
from the gallery, yes, I would like to think that they always come prepared, because they should.
We always assume that they are prepared.
Yes.
We always assume.
Where does the fault lie now?
I think that remark or observation has been made by the Senate President, not simply because of what has been observed to be the ill-preparedness or lack of preparation on the part of the prosecution, but it is more than that. I think when the Senate President referred to the Constitution, it is more on the rule of law.
Yes.
So it should not really be, while this is a political process, as they want to describe it, it remains fundamentally legal. And when you say it is fundamentally legal, you only have to anchor the proceedings on the basis of the Constitution. And this is, where we are right now is based on that constitutional provision, on where how impeachment should be initiated, how impeachment should be derived, and that therefore there are rules that they have to follow. There are laws to be followed. There are rules that have to guide us. So when we talk of the Constitution, you talk of laws, you talk of rules. That's the rule of law. You cannot go beyond, do things outside of the Constitution, outside of the laws, and outside of the rules. Now, the rules may be made flexible depending on the exercise of the sound discretion of the impeachment court, of course, through the presiding officer. But that's their call, not ours. What the Senate President was reminding the prosecution is that we are doing what we are supposed to do under the Constitution. You should be doing what you're supposed to do also under the Constitution. So the proceedings must therefore be circumscribed within the context of the Constitution. You cannot go beyond.
Atty. Ramon Esguerra, thank you very much.
Thank you, thank you so much. Thank you.
Thank you for joining us once again with the Defense Chronicles. This is Leslie Bocobo.